So it seems not only was it reported that the UK government wanted a backdoor into Apple's software to get access to personal data, it seems now from a judgment that's been handed down that when Apple challenged this in court, as I predicted they would, that they wanted to have these hearings in private, or some might call it secret. So there is a partial judgment handed down from a fuller judgment which has been kept private, which I'll look at in this video. And there's also a few other, let's call them questionable things by this government I'll touch on later in the video. Please do stick around for those. And if you enjoy this content, please do consider subscribing, because whilst I am still out and about traveling, as you can obviously tell, I am still here looking at doing some videos for you. So this really caught my attention, because this is quite a serious thing, because this was a claim filed in the Investigatory Powers Tribunal. This is where there are any issues raised with regard to the Secretary of State's powers to make technical capability notices, which they still haven't confirmed or denied that they exist. Neither party has made any comment at all, really. But one of these notices, if you remember, if issued under the Investigatory Powers Act of 2016, it's where the government requires a company to make a capability to allow them access to certain bits of software. So essentially, the government reportedly wanted Apple to give them a backdoor into software to access private data. Now, again, there's arguments for and against that. On the one hand, they should only be really going after the most serious offenders and therefore need access to that information. On the other hand, it's a massive breach of privacy for everybody else. Apple flat out refused to build a backdoor. In fact, they turned it off. It's just an advanced form of data encryption. Many of you probably didn't even know it existed and have never heard of it or wouldn't have known where to turn it on, because I don't think it comes on by default. It may do now, it never used to, but by the by. So there is a partial judgment handed down, and the tribunal has said that this is not going to be a secretive hearing, entirely at least. So leading the tribunal, Lord Justice Singh and Mr. Justice Johnson handed down a partial judgment, the remainder of which remains private. So they set out the claim at the outset of this judgment, saying that the Home Office's response to this claim said that it would be damaging to national security if even the fact and the very basic details of this claim, or the identities of the parties of the claim, the bare details, were published. But of course, many news organisations had reported on this already, and indeed, what I was quite interested to see, that there were quite a few news organisations that made their thoughts and feelings known about open justice. They argued that the media should have the ability to make effective and informed submissions against an order which would restrict open justice. Interestingly, the tribunal noted that there'd been significant media reporting that the government had issued one of these technical capability notices, but also noted that neither Apple or the Home Office confirmed or denied that any of this reporting is accurate, and noted that this judgment should not be taken as an indication that the media reporting is or is not accurate. So that in and of itself is interesting, because this is a claim about something that they haven't confirmed or denied exists in the first place. So I'll link the judgment below and you can read it for yourself. But interestingly, there are specific rules that apply to this type of tribunal. Under Section 69 of the Regulation of Investigatory Powers Act 2000, it empowers the Secretary of State to make rules that govern the hearing or consideration of any proceedings or complaint with regard to this tribunal. Under that section, it says, in making rules under this section, the Secretary of State shall have regard in particular to the need to secure matters which are the subject of the proceedings, complaints or references brought before or made to the tribunal are properly heard and considered, and the need to secure the information is not disclosed to an extent or in a manner that is contrary to the public interest or prejudicial to national security, the prevention or detection of serious crime, the economic well-being of the United Kingdom, or the continued discharge of the functions of any of the intelligence services. So again, very broad rules to ensure that none of this has any impact on any of those things. The tribunal then considered that it had a statutory duty to carry out its function in accordance with these rules, weighing up the appropriate evidence and views. However, for reasons not disclosed in this judgment, the tribunal said, for reasons set out in the private judgment, said that it does not accept that the revelation of the bare details of the case would be damaging to public interest or prejudicial to national security. The tribunal then summarised the thoughts and the views of the media, including the BBC, 9 other media organisations, PA Media, and even US senators and members of Congress, and then explained that because it has dismissed the Home Office application for the hearing to be in private, and have therefore not made an order restricting open justice so far as is necessary on an interim basis, and will make further case management orders in due course. But what else do we have to talk about here? Well, as I said, there's been a lot of questionable statements made by this government. Now, one of the things that's really raised my eyebrows a bit is the arguments put forward with regard to VAT on school fees. We're back on that old train again, because one of the arguments put forward, and I think this is utterly ridiculous, and I've even commented that lawyers cannot just put forward arguments that are absolutely outrageous, that to a degree we do have to just follow instructions, but we do also have to push back against clients a little bit. Now, I'm surprised that this argument has been run in court in this VAT case. The argument that's been run is that the parents of privately educated school children need to, quote, pay their fair share in order to support the rest of the state school system. And I think that is a little bit of a silly non-starter argument, and I'll tell you why. Because the parents of children that go to private schools not only pay essentially for the state school place that they do not use through their ordinary taxes, but then they also pay for the private school fees, and now they are also having to pay VAT on top of those fees, at least unless and until this court case may rule in their favour and therefore not have to pay it anymore. If it's ruled to be unlawful and remitted back to the government to reconsider, that might be one of the outcomes. But how then are they not already paying their fair share? To me, the question would be, well, what is the fair share? Obviously, the response to that from them would be, well, the VAT on those fees. But how is it that they are not already paying a fair share when they're already paying for the state school system as everybody else is? There is no rebate from the state school system. There is no special discount off private school fees or anything like that because you pay your ordinary taxes. And so by paying for the state school place and the private school place together, and now obviously with the VAT, how are they not already paying for the fair share? I think that is a nonsensical argument, and I'm surprised that that's been run in court. Now, it's okay, I suppose, to run an argument that you don't believe, and we're not required as lawyers to believe the arguments that we run. We are required to press and act with honesty and integrity, and that is a very broad core duty. We have a lot of core duties. This is core duty 3, to act with honesty and integrity, and that includes everything that we argue in court must have an integrity behind the argument put. For example, we cannot ask a question if we know that the answer is going to be a lie, or we cannot suggest that somebody was not in a given place when we know that they were in that place at that time. And this throws up a whole heap of ethical arguments and debates. So, for example, somebody will often say, how can you argue that somebody didn't commit a crime if they've admitted to us that they did commit that crime? The simple answer is we can't. We can't do that. For example, if someone's admitted to us that they've committed a crime, we cannot suggest in court that they didn't. We cannot suggest that they weren't there. We cannot suggest that they didn't do the thing that they're accused of or any elements of that offence. If they did do that, and we know they did that, we cannot suggest they didn't. This would be against our core duty to act with honesty and integrity, because we would be misleading the court if we suggested or put forward an argument that they were innocent or they didn't commit the crime when we know that they did. So that is why I'm surprised at the argument being run here about private school parents paying their fair share. Now, it's a very weak and tenuous argument at best. Pay their fair share? I think that's a bit odd. Now, these rules are even stricter if the arguments are in writing. If we know that it is just not a proper argument, we cannot commit that if we're drafting witness statements or affidavits and such. We cannot put that in writing if we know that it is not properly arguable. Just like fraud. A lot of clients, believe it or not, a lot of clients come to us and say that this situation is fraudulent. Even sometimes they say that judgments are fraudulent, or someone going to court has been fraudulent, or they've perverted the course of justice and all these sorts of things. We get all sorts of comments like that. But unless we have two things, both instructions and some sort of factual basis of evidence that supports that contention, we cannot commit that contention to writing as a witness statement for that client. We don't just simply write whatever the client wants us to put. And likewise, for me, we don't just throw any argument that the client says to throw in court either. I would put forward properly arguable points in court And most lawyers, and particularly barristers, will certainly relate to this point here, I hope, that there is a phrase in court that barristers sometimes use: I am instructed that this happened. Now, one of the reasons that that's put forward is if you get instructions late, or you haven't had the time to properly read through things, or you really haven't had the time to read into it, but it's better that you put the argument forward as an advocate than not at all. And so then you might say, I'm instructed that this happened. It's sort of a code way of saying, this is what they tell me happened. I've not necessarily researched it myself, but this is the argument that they are putting forward. But I don't like to put that forward. What it suggests to me is that you haven't really considered the argument properly. For me, I would prefer to say, this is what happened. Because if I'm the advocate for my client tells me that it happened, I don't necessarily have to believe them 100% to make the argument. But as an advocate, to put that forward strongly, I don't like the phrase, I am instructed that. But this would be one of those cases where I might say that I am instructed that the government's view is that these parents should pay their fair share, because I don't think that's a proper argument to make. But that's just me. And so I think a few lawyers might have a few thoughts about that. Certainly the parents might have a few thoughts about that, in that they probably do feel that they've made their fair share. And other disappointing things recently, while I'm here and reading the news, I read that the grooming gang inquiries have been, let's just say, I'll be generous and say significantly watered down, in that they are not now specifically supporting those 5 inquiries. And I think that they should, quite frankly, because all of the statements to say that they wanted to look into this and they wanted to find out exactly what happened, they wanted to support all of these victims and find out really how they were failed and what truly happened, that can only happen with a proper inquiry. And that is, of course, why Rupert Lowe MP has set up this private crowdfunder to support the rape gang inquiry, which has now raised over £540,000. I will link that below. You can read about that yourself. There will be a properly appointed panel and advisors to the panel. And so this will be run properly and professionally. And whilst it may not have all of the same powers as a full-on statutory inquiry, it will certainly be a substantial inquiry into what happened, looking at representatives from local authorities, from police forces, from the CPS, social services, local education authorities, because I won't repeat them here, but some of the things said in Parliament about some of these victims are utterly horrendous, to a degree that I simply will not repeat here on YouTube. You'll find videos explaining what these are from statements made in Parliament, and so therefore I'm quite frankly appalled that the official support for a statutory inquiry appears to have been withdrawn. Despite all of the discussions in Parliament, despite all of the political statements made of supporting these girls, these victims of these horrific crimes, it now appears to have just moved on. And that is unacceptable in my view. I think you probably agree with me. Let me know in the comments down below what you think about this. I think that is utterly disgraceful. But we are where we are, and so I'll link the crowdfunder in the description below as well. Let me know what you think about anything we've discussed in this video today. Thank you for watching while I'm here, and I'll see you next time.